The Supreme Court begins its term today, with in-person arguments sans Justice Brett Kavanaugh, who is COVID positive, though we hope and expect he will appear in the flesh soon, since he is vaccinated and symptom-free. Among the cases up for argument on day one is a sentencing issue under federal law. I mention it because it is relevant to the discussion of federal sentencing in an essay I wrote for the last issue of the magazine, Fictions of the Carceral State. Advertisement At issue in Wooden v. United States, as Daniel Harawa explains at SCOTUSblog, is the vexing question of what is meant by the word occasion. In 2014, when James Wooden was arrested for being a felon in possession of a firearm, federal prosecutors charged him with being an armed career criminal under Section 924E(1), a penalty provision in the firearms part of the penal law, added in 1984. This prescribes a mandatory minimum 15-year sentence if the felon in question has 3 prior violent felony convictions committed on occasions different from one another. Wooden has 12 prior convictions, all committed before 2006. There is an unresolved dispute over whether a 1989 aggravated assault qualifies as a violent felony, but a 2005 burglary conviction clearly does. What about the other 10? That's what the Supremes have to sort out. Advertisement in 1997 Wooden burglarized a storage facility in which many warehouses were situated. Wooden entered and stole from 10 different mini warehouses and was convicted of a separate count of burglary as to each one. Advertisement So, did Wooden engage in one occasion of burglary that had 10 related subparts? Or were there 10 occasions of burglary since A, Wooden could not have been physically present in more than one mini warehouse at a time, so there was clearly some separate deliberation between each burglary, and B, consistent with that, he was convicted of 10 separate crimes? The answer is different depending on which circuit is answering it. The Sixth Circuit says there are 10 separate occasions, the Second Circuit says it's 1. The circuit split is why the court took the case. I'd note, as I did in the aforementioned essay, that there would have been no issue prior to the reforms of the 1980s.